wanted completely to join you on this idea of the CP done by the UIPO and the national levels, because for me, it's something which might be interesting also on a global level, be it the CP12 or those before, which were on how much of acceptance do we give to elements of proof of internet, or sooner it was a question of weak trademarks in opposition proceedings, etc. It's really very soft harmonization, but really helpful, even though it's on the administrative level and then has to be accepted by definitive judgments of the tribunals. But I think this is the good way to focus on certain points and then to try to find solutions.
Iris, insofar as bad faith is concerned, the European Court of Justice has laid down very good guidelines to be followed. These are guidelines that we in Singapore follow. I'm sure, Andrej, you agree that those guidelines are very useful.
Yes, I think that on the bad faith, there are already quite a lot of cases from the Court of Justice, also now a lot of cases from the General Court. We are frankly surprised how many cases we have in bad faith in the current times. It's really, I would say, a multiple in comparison to what was previously. And they are on all the aspects of possibility of what can come in bad faith situations. So I think that some precisions are still coming. But yeah, the case law is, I would say, quite clear already.
However, the ultimate objective would be to have less cases go to court, right? The ultimate objective would be to have many of those applications rejected at the office level and, let's say, disengage the courts from these cases, and also not force brand owners to take it even Dedar to the Supreme Court level in cases that at times are quite obviously bad faith cases. So I think that is what these, let's say, grassroots attempts at harmonizing definitions and applications and interpretations are trying to do to keep those cases out of court. That would be ideal.
But we need our jobs, Iris. Just to prove that I am not fully against harmonization. If you talk about having international trademarks or worldwide trademarks, I would totally agree with that. I think that would be the ideal situation to have. We would have no problems. But since we already have our national systems, I think it's kind of utopic to have that, at least considering the past, because if you create a new trademark, you have to see in every country if someone has that an identical trademark or not. But I think it can be the future. I think that it would be ideal for everyone.
Yeah, and I think that's our next project then.
Yes, but I think your idea about having a dictionary of these major questions that we face in every judiciary, because we have similar problems in every country, it would be an amazing idea to work on it. With lots of examples, it would be great.
So when can we start?